Thank you for joining us this evening. You're now attending the webinar entitled The Earliest Supreme Court. Our leader for this session is Sally E. Hadden, NHC Fellow 2324, Professor of History, Western Michigan University. We're also joined by our TAs for this evening, Ryan Hurley of Urban Community School, Cleveland, Ohio, as well as Luke Sundermeier of Marysville High School. Marysville, Ohio. Both are members of this year's Teacher Advisory Council who will serve as our TAs for tonight's session. They'll be active in the chat, sharing thoughts and resources and asking questions. Sally Hadden is a legal historian of early American and antebellum United States. She received her history doctorate and law degree from Harvard. Her book, Slave Patrols, Law and Violence in Virginia and the Carolinas, described the white on black violence that pervaded America's slave societies before 1865. She co-edited the Blackwell Companion to American Legal History with Al Brophy and Signposts, New Directions in Southern Legal History with Patricia Mentor. Hadden is a past officer and board member of the American Society of Legal History and recipient of its Craig Joyce Medal. Hadden also serves on the editorial board of Law and History Review. She is editor of publications for the Colonial Society of Massachusetts and a member of the history faculty at Western Michigan University. Hadden has received many grants, and one that she is particularly proud of is her fellowship with the National Humanities Center. With Mabel Marcus, she is writing a study of the first Supreme Court and its English colonial and revolutionary forebears, which form the subject of her National Humanities Center Fellowship, and the basis for her presentation and talk this evening. To our teachers who are joining us from all over the country, without further ado, I present to you our speaker, our scholar, and our leader for tonight's session, Dr. Sally Hadden. Sally, thank you for joining us. We look forward to hearing your talk.
Thank you, Mike. Welcome to this webinar on the earliest Supreme Court. And I want to take just a moment first to thank Mike Williams and the educational programs team at the National Humanities Center for this invitation to participate in the webinar series. I think there are few more important things that I do as an educator than to help others understand our country's history and its legal system and how it worked as it did in the past. So thanks to Mike, and also I'd like to thank all of you who have tuned in to this webinar, for taking time from your busy schedules to learn more about American history and in particular its legal past. So I'm going to begin by giving you an overview of the material that I'll be discussing tonight, just to provide a roadmap, or if you're in a movie-going frame of mind, a preview of coming attractions. First of all, I want to tell you a little bit about the differences that exist between constitutional history and legal history, to provide you with some context for the material that you're going to hear later on. You may have heard people talk about legal history and constitutional history as if they're one and the same thing, and I'm going to help you figure out why they're not precisely the same, and also why that might matter. Second of all, I'm going to give you an overview of the One Supreme Court project that I worked on while I was at the National Humanities Center as a fellow last year. That overview will allow you to see how the materials that you read and the Levine case in particular fits into the overall book project that I've spent the last couple of years working on. So I'm going to give you a summary of the material that I and my co-author Mabel Marcus have been researching and writing, and also explain a little bit about why we launched the project and what we hope to accomplish when we're finished and the book is published. Third, you're going to learn a little bit about how about that English and colonial background and how that set the stage for the judiciary that is that we now take for granted as part of the United States government. The bigger story is that structural separation of the judiciary from other parts of government was not a foregone conclusion for most of our history, all the way up to and including the Constitutional Convention in 1787. For a very, very long time, courts served the will of the executive, whether that executive was a king or a royal governor. And courts operated in legislatures too, whether it was Parliament or in the colonial period in legislatures like Virginia's House of Burgesses. So I'm going to walk you through some of my findings about colonial governors' councils. And there, again, I'll touch upon the Levine case, the material that you read to prepare for this webinar, and talk about how it fits into one of the chapters I wrote at the Humanities Center. And I'm also going to talk eventually and at the end about where the idea of a Supreme Court came from. The idea that one court needed to be supreme over all others is where this will, the last thing that I'll try to cover. But finally, we're going to open it up for questions from the audience that's tuned into this webinar, and I'll do my very best to provide answers to the things that are on your mind or that come up while you're listening, particularly questions that the readings may have raised for you as you prepared. But let me be pretty clear about one point, and that is that I'm a legal historian, not a modern-day political analyst. So if you've got questions or want me to offer commentary about the current Supreme Court or a specific case that maybe has happened in the last 5 or 10 years or something like that, I am not the right person to ask. All of the politicians and judges that I think about and write about are dead, buried, and 6 feet under. They are currently not sitting on the Supreme Court. So I'm stating right up here at the front that if the stuff that interests you the most relates to recent court cases or judicial decisions, say after 1800, I'll only be able to give you an opinion that may be as well informed as your own. I'm a scholar of the 17th and 18th century and legal action that was happening then, which in my view was pretty fascinating. So with that caveat in mind, let's get rolling. We begin by defining the realm of inquiry. What is legal history, and how is legal history different from constitutional history? There is a difference, but I'd be willing to bet that few of you have thought about what sets them apart, and that's where we're going to start. When I tell people I'm a legal historian, I can tell that in their minds, most of them immediately flash on an image of the Supreme Court building, or maybe they think about justices on the current Supreme Court, because to most people, our highest court represents legal history. The first thing that pops in their mind is that building. And for other people, maybe they get a picture in their minds of the Constitution, the document. Maybe if they've paid a visit to Washington, D.C. and paid a visit to, they've stood in line to look at the documents like the Declaration of Independence and the Constitution. So they think about the Constitution and how it defines our government. So for many people, if legal history isn't the history of the Supreme Court, it's the history of the Constitution. Well, what they are thinking of is actually constitutional history. And for a long time, constitutional history was the only kind of legal history that people like me read or wrote or taught. Until the 1950s, in fact, nobody really wrote any other type of legal history except to focus on the history of the Constitution or the history of the Supreme Court. But studying the Constitution and the Supreme Court is not all that legal historians do. Actually, constitutional history is a subset of legal history as a whole. Constitutional history focuses only on the U.S. Constitution and its chief interpreters, the Supreme Court. And in fact, constitutional history is just a drop in the ocean when you consider what legal history includes. Now, that's not saying that constitutional history isn't important. It absolutely is important. But this just helps you get an idea of the relationship between constitutional history and legal history. So let me briefly introduce you to the wider range of topics that legal history can include so you'll understand the distinction between these two fields and how that may play out in the work that I've been doing. So an awful lot of legal history is about legal activities that are not related to the Constitution and have nothing to do with the Supreme Court or what it decides. Let's think first about the many other courts that exist and what kind of work they do. There are federal district and appeals courts, state courts of various kinds. There are local courts. That's actually where I got my first taste of law when I was 16, and I ended up having to sue my employer for not paying me for 2 weeks' worth of work. There are also courts that are managed and run for specific groups like Native Americans or the military. The engraving here shows you a naval court-martial being held on board of a ship. And that's just courtrooms that we have in the present day or in the recent past. Of course, in the past, there were courts on medieval manors. There were, then and now, there are religious courts, like the Roman Catholic Church has to handle annulments of marriages, or courts led by rabbis to resolve divorce and other disputes. And there are courts that popped into being only for a very short time, like the ones that appeared after World War II to try the Nazis at Nuremberg, or courts that are designed to resolve disputes between countries, like the International Court at The Hague. Legal historians are interested in courts that exist in many places and many periods of time, like the show trials of all of Stalin's enemies in the Soviet Union. Stalin used those courts to persecute his personal and political enemies. And the courts weren't really about delivering justice at all. The decisions had already been made in advance. And where constitutional history is primarily focused on the Supreme Court or the decisions that it has handed down related to the Constitution, legal history doesn't have to even happen in a courtroom. Now, it might happen in a courtroom, like that naval court-martial we just saw, but remember, a lot of law also happens outside of courts, in situations where people use law informally, where law is dreamed up or written down, where it's interpreted by people who aren't judges, like the IRS or the Border Patrol or the Immigration and Natural Services agencies. It's something that can have a legal history when people think about the law, sometimes when they even just poke fun at the law. The image here is of a gathering that took place in the early 1870s, when the United States had a dispute with Great Britain about a ship that was built during the Civil War, a vessel built for use by the Confederacy. And the United States claimed that by allowing the South to build such a ship in its docks, England had violated its neutrality. And so to resolve the financial issues surrounding the ship, the two countries agreed to arbitration, which happened, of all places, in Switzerland. So legal histories are needed about these kinds of situations as well. But legal history isn't just about court settings or law that happens outside of a courtroom. Legal historians are also interested in the people who are affected by law, and that potentially is everybody. We're interested in criminals, but we're also interested in people who follow the law. And of course, any group affected by law will have their own legal history. So you could add to the list of people who've got a legal history infants or the disabled or people in a particular industry, even the dead. There are laws governing how we dispose of corpses. And for every type of law that affects individuals, there is a legal history to go with it. Another angle to legal history is to think about the place where law happens, not the setting, but the geographic location. So you might be interested in knowing more about the legal history of a country or a state. One of the most intriguing books to appear in recent years had the title Who Owns the Sky, which was written by Stuart Banner at UCLA. And the answers that Stuart came up with as a legal historian are absolutely fascinating. We've known that people have written about the law of the sea and the legal history of the sea for generations, but people had never really studied the sky before. So when new places open up, new legal histories are needed. And so what that means is next stop, the law of outer space and legal history in outer space. You might also think about the types of work we do in society, as well as our hobbies and amusements. Every single one of them may be affected by the law, and therefore it has a legal history to it. In the legal history of the internet, one of the biggest questions people wanted to know about is who owns the internet? Should the FCC be able to license internet service providers and access to the internet the same way that we license electricity or water as a shared public good? And again, that comes with a legal history. In the legal history of literature, people have studied fictional courtrooms and how action in those fictional courtrooms shaped people's views about law. How did people perceive courts or justice after they read about trials in Charles Dickens or Herman Melville? Whereas in sports, what kind of legal principle makes drug testing? Athletes, okay. Where did athletic drug testing even come from? For every hobby or every endeavor that has a law, there's a legal history. So the list here is endless. So by this point, I've probably convinced you legal history can be approached from practically any angle. I'm just going to offer up two more, and here they are. I'm really interested in personnel who make their living from the practice of law. That's not people who are affected as parties by the outcomes of what judges decide, but the people who make their living, earnings based on the law. So like judges and lawyers. You can write a biography of a judge like John Marshall, or you can do what I've been doing and study lawyers in colonial America. And of course, all of these examples that I've been pulling out, most all of them, are about America. Legal historians of ancient Rome write about praetors and censors and famous trial lawyers like Cicero, who apparently was a first-rate public speaker. And although there are many more areas of legal study that I could name, here's one last area of a legal history that you ought to know about. And that's the study of legal principles and how they emerge or disappear. Now, these principles are the ones that are used by judges to decide cases, but we discuss and debate them at a general philosophical level. So to give you an example of a legal principle that you could understand this way, legal historians are interested in how we resolve disputes when people have accidents. And the typical rule that we use is the reasonable man standard. So you're at the grocery store and you look in your rearview mirrors as you get ready to back up your car, and unfortunately you have an accident because somebody else was backing up their car at the same time. Well, a judge is going to apply the reasonable man standard to try to figure out what would a reasonable person do in this situation, and how would a reasonable man have acted in the setting you found yourself in. But there's another specific type of legal principle that applies when people have accidents. And we expect more when there are companies that are involved in what we think of as dangerous activities, and places where if a mistake gets made, the disaster is more than a busted fender. And so the example I'd offer you here is that of a chemical company like DuPont. DuPont makes explosives. They used to make nitroglycerin, and everybody knows what happens when nitroglycerin blows up. So if DuPont as a company has an accident with its explosives and they get taken to court, the judge will not be applying the reasonable man standard, because DuPont should have known, hey, everybody knows they deal in dangerous stuff, and everybody who works at DuPont, including their executives, understands that they might be held to a higher standard, that strict liability standard. But here's the catch. Strict liability as a legal standard did not always exist. And the same is true for some crimes that existed in the past and don't exist now, like witchcraft, or that didn't exist then and do exist now. Legal principles evolve and change with time. And some scholars, especially those who teach in law schools, are very interested in the legal history of these abstract principles. Now, one reason they're so interested, of course, is that if they can identify how principles have changed in the past and why, they might be in a position to predict how those principles might change in the future. So there's a legal history for every era, for every epoch, for every country, whether it was ruled by an emperor, a shogun, a sheikh of the desert, or a president, because you can link law to every field of human endeavor, inside and outside of courts, because law is everywhere. And all of those legal settings, whether it's people involved in the law or legal ideas, courtrooms or no courtrooms, they all have legal histories. And one of the most marvelous things is that legal history is a relatively young field, because up until about the 1950s, almost everybody was working on constitutional history, and meaning that there were vast areas still waiting to be explored. The newness of the field of legal history is one reason why I really like working in it, because there's so much that we still don't know, and so discovering it or researching or writing about it is really exciting. So before we move into the next section, I just want to pause here and see if Mike or the TAs want to pass along some of your questions to me about this first little bit.
All right. Thank you so much, Sally. I'll encourage everyone, if you should have any questions, please enter them in the managed Q&A chat box. We had a few from pretty early on. One of the early questions was about the Supreme Court and term limits, and what's the basis and justification for not having term limits?
Well, as you'll find out in coming up eventually, our legal system and legal processes are based largely on England's common law processes in courts. And in England, there were 3 different types of ways that you could be appointed as a judge. You could be commissioned during the king's pleasure, meaning that the king could hire you today and fire you tomorrow, right? Or you could serve forever, but so long as the king is happy with you. The second way you could be commissioned as a judge in England was to be commissioned during good behavior, which meant you served as long as you didn't do anything corrupt, like you didn't take money from a party, or you didn't reach a decision that was manifestly wrong. So typically, if you serve during good behavior, you might serve until either you resign or you die in office. And that's actually what we have in America with the Supreme Court, is service during good behavior. All federal judges that are considered Article 3 judges serve during good behavior. And the third type of appointment that happened in England was to serve for a set term of years. And that might be 2 years, 5 years, 10 years, but it was a set term of years. And in 1688, they had something called the Glorious Revolution, and they basically ran the king out of town. King James II was basically threatened, and he fled the country, and they had the Glorious Revolution, and William and Mary were invited to come over from the Netherlands, and they became king and queen of England. And from that point forward, the king was and is still only supposed to appoint judges during good behavior. But the rule that applied in England after 1688 did not apply in the colonies. And so the colonies were excluded from that change. And so in the colonies, judges were appointed, continued to be appointed, using typically two of those three methods, either during the king's pleasure or during good behavior. But more and more often, they were appointed during the king's pleasure. And in the 1830s, and then again in the 1730s, and then again in the 1750s, many judges and colonial politicians began to fight back against that policy that the English politicians had put into place of only appointing people for the king's during the king's pleasure, because they said, why should the colonies have one style of appointment and England should have another? And so when the revolution happened, almost every state went to a practice of appointing the judges during good behavior. And it was only really in Pennsylvania. Pennsylvania's Supreme Court appointed their judges starting in 1776 for a term of 7 years. But the question is about term limits, which is a little bit different than term of years. But I wanted to foreground all that information because what you should see is that most judges, when they get appointed, they've got a job for life and not a job for just a few years. Part of the reason for that, the philosophy behind it, is that judges are viewed as holding a fundamentally different position from other types of officials. And the idea being that they should be insulated from the comings and goings of the political parties and the winds of change that kind of bash around the other branches of government. But having said that, in a lot of states, state governments moved to electing judges in droves in the early 19th century. In the early 19th century, many states moved from appointing judges during good behavior to appointing judges by election. And I think the reason why term limits never really took off, to get back to Lillian's question, is because so many times state judges are elected. And so we don't really worry too much about the fact that federal judges are appointed during good behavior. And I hope that answers your question, Lillian.
Very good. Thank you so much. And we have a few more questions, but I'm going to hold those questions because I feel that you're going to cover some of these topics. So I will bring them to your attention a little bit later on, and we can move ahead.
Okay.
All right.
Great. Right. So let's move into learning about the One Supreme Court project and how, as a legal history, it's different from some of the constitutional history that went before. One Supreme Court's a book project that I've been working on and that I worked on as a National Humanities Center Fellow. And I've been working on it with my friend and co-author, legal historian Maeva Marcus. And there she is in the picture. She works at George Washington University Law School, but before that, she was the senior editor of the documentary history of the United States Supreme Court project that ran for 25 years. The project spent all that time recovering the papers of the early Supreme Court of the 1790s. And if you're wondering why they had to be recovered, it was because of the War of 1812 and the burning of the Capitol. And so her team spent that time collecting the papers of the early court from so many different locations. And they published their findings in 9 volumes, covering more than 20,000 documents. So if there's anybody who knows the Supreme Court of the 1790s, it's Maeva. And she wanted to write a book about the 1790s court, but she realized that to do that, she really needed to build it on a foundation that would include the legal history of England and America's colonial past and its revolutionary experience and its Articles of Confederation period and all the stuff that came before the 1790s. And so she called me up and said, would you join me? And I said, yes. So One Supreme Court is about the creation of the earliest U.S. Supreme Court, but it starts with that prehistory, if you will, that leads up to the 1790s by looking back to the forebears of the court that you can track back to the 17th and 18th century in England, as well as early court processes that existed in early America. And so that's why what we're writing is a legal history and not just a constitutional history. Most histories of the Supreme Court actually start at 1801 with the tenure of John Marshall, who obviously became Chief Justice in Thomas Jefferson's presidency. Many of the critical decisions that were made during Marshall's tenure still affect the way that we think about judicial review or the relationship between the national and state governments or about checks and balances between the branches of government. And it can even be hard to recall that there was a time before Marshall to remember that there was a period when the judiciary was not the equal counterpart to legislatures or executives in early America. And that's where our book comes in. We wanted to try to explain the development of judicial structures and practices in the context of this earlier period, before Marshall, before 1801. And so that should maybe help you understand why in this co-authorship, Mava is the 1790s expert. I'm the one who's writing about the English colonial revolutionary Articles of Confederation stuff. And so that's why this webinar is so heavily tilted towards the English and colonial eras rather than being about the 1790s. So you might be wondering, hasn't somebody tried to write a history of this period before? Hasn't somebody actually tried to write a history of the court before the 1790s? And a partial answer is yes, but a better answer would be yes, but not very well. The first person to attempt a study of the Supreme Court and what went before to try to reclaim some of that English and colonial stuff was Julius Goebel. Julius Goebel was a professor at Columbia Law School who spent about 20 years putting together this kind of an early history, and he published it in 1971, and it weighs in at 864 pages. In 864 pages, Goebel tried to capture what he called the Supreme Court's antecedents and beginnings to 1801, basically everything that came before Marshall as a Chief Justice. But here's the rub. Of that 864 pages, probably 100 pages or less was devoted to the English and colonial eras. He spent 50 pages on the Continental Congress. He spent another 60 pages on the Constitutional Convention of 1787. There was 40 pages devoted to the ratification debates, and the balance of the book, more than 500 pages, was on the period from 1788 to 1801. So really, there's only about 100 pages on the English and colonial era, and many, many hundreds of pages on the period after, say, 1775. So you can understand why somebody like me, who works on legal history before the Revolution, might go, hey, wait a minute, hold on. Why so little on the English and colonial bits? And so that's one of the things that our book will change. Our book structure is 11 chapters, with half of the book we're writing on the period up to 1788, and the other half on the period after 1788. So part of our purpose is to rebalance the telling of this early court history. And we can do that because we have available to us a much, much larger body of primary and secondary scholarship than Goebel had. When he was drafting his text in the 1950s and 60s, documentary editing in the United States had only been underway for just a few people for barely 20 years. The first volume of the Papers of Thomas Jefferson appeared in 1950. So we can call on, Mava and I can call on more than 60 years worth of documentary edited collections, the papers of Presidents Washington and Adams and Jefferson, and edited documents about the first Federal Congress and the early Supreme Court that Mava edited, and paper sets on individuals that are both in print and online for people like John Jay or Alexander Hamilton, and the list goes on. We have available to us a mountain of primary source material that Goebel simply couldn't call on. And the same can be said of the scholarship that exists about the 18th century, which since 1971 has moved on in a myriad of ways. We have studies now of travelers and traveling accounts, which are vital if you want to understand what happened when the Supreme Court judges went out riding on circuit. We have new scholarship on book buying, which is essential if you want to know which law books these men owned and read. We have new studies of masculinity and sociability to better understand what they were doing when they weren't busy being judges. We know more about the economy and how they got paid, and the list on this is practically endless. We not only know more about the 18th century world in which these men lived and worked, but all of this allows us to take a very different approach to that world from how Julius Goebel operated. That's the reason why he wrote about the constitutional history that he did. If he could focus strictly on the decisions of the court, then that's how he could write a long book. We're going to be writing about so much more because there's so much more available to us. Marcella is asking a question in chat. Did I understand correctly that Jefferson's papers weren't published until 1950? How's that possible? The answer is there were earlier versions, but those earlier versions of Jefferson's papers, Adams' papers, and Washington's papers were not edited with the modern scholarly apparatus that we now take for granted. All of the footnotes that identify the people he wrote to, the editors of modern documentary editions no longer edit out the bits that people find offensive or racist, whatever. The documentary editions starting in the 50s were just done to a much different and much higher standard. So you've already learned that legal history and constitutional history aren't the same thing. Well, in a nutshell, what Goebel was interested in was strictly the constitutional history, the courts, the judges, and the legal principles that they used to decide the lawsuits. Working in a law school with only, legal history was such a new field that only really got kicked off in the 50s. Goebel was writing as a man of his time, when the only thing that really mattered was the constitutional material. So in telling the story of what came before the Supreme Court and the court itself, Maeva and I are going to be drawing on this major sea change that's taken place that puts constitutional history kind of really just in a corner of legal history as a whole. And in fact, it's studies like Goebel's that many people think of when they think about the court or Congress or the presidency, when they think those kinds of studies are old-fashioned. And that's because we've had multiple generations of scholars, good scholars, who were intensely focused only on the institutions and the men who ran them. But this approach no longer satisfies legal historians. An analogy here would be to religious history. It doesn't satisfy religious historians just to study the sermons that were delivered by particular ministers. To get a fuller picture of religious history, we'd want to know things like church music, what kind of music got played, the books and the texts that were used in that church aside from the Bible, what kinds of things people did before and after a church service, what kind of a building they met in, and so on. You get the idea. A church is more than a minister and a text, and the same is true with the Supreme Court. So we intend to go beyond what Goebel did by putting the court and its forebears into a broader, let's say, less top-heavy institutional historical setting. So the approach to this project is I'm drafting the first 5.5 chapters. Maeva is going to draft the last 5.5, and we basically meet in the middle of chapter 6, which is on the first Federal Congress and the work that it did to create the first Supreme Court. So my part is really about the groundwork to this American story, starting with England from the 1600s and following that up with American material from the 1600s and 1700s. And by starting then, we'll give the reader a better grasp on how the Supreme Court was possible and what options existed for its design and its procedures and its powers. Today we have a tendency to think of the Constitution as iconic. It must have been. And we tend to forget or downplay the roads not taken, the opportunities that they had, the options in front of them that existed in the 1770s or 80s, even after the revolution had been won. And so what this is trying to do is to restore some of that sense of contingency to the choices that those early politicians made. Okay, so now you've got a better understanding of how I came to join Mava in writing the book and some of the differences between legal and constitutional history. I'm going to take another break here to ask if there are questions before we move on to looking at English and colonial law in that particular world.
Okay, thank you. Thank you so much for that. We appreciate it. And for those of you, there are questions that are appearing in the audience chat from time to time. And thank you, Sally, for picking up on one earlier and responding to that. There were some earlier questions that we had. And I know that there will be a discussion about this, but presidents packing the Supreme Court, is that something that you want to hold off on? There's a question that Eric had from earlier. Have presidents tried to pack the Supreme Court in the past to control the judiciary and get their candidates elected to pass their agendas? I wonder if a discussion of just court packing in general, that's something that you would like to.
Yeah, I can take that up for a moment or two here to try to help answer Eric's question. And if that's not sufficient, we can return to it in the Q&A later on.
Indeed.
The president most clearly associated with court packing was Franklin Delano Roosevelt in the 1930s, and his actions to do this were based upon the fact that the various programs and initiatives that he put in place to try to help get the United States out of the Great Depression were being repeatedly struck down by the Supreme Court as unconstitutional. And typically they were being struck down by fairly close votes, like 5-4 or 6-3, but usually 5-4. And so Roosevelt, having seen not 2, not 3, but several of his programs and proposals get struck down by the court in the 30s, proposed a court, what came to be called a court packing process, where he suggested that every judge over the age of 70, that for every judge over the age of 70, that an additional judge be appointed. The idea being, at least on the surface, well, we don't want people working too hard when they get elderly. Everybody saw through this for the fabrication that it was, and a great howl went up across the United States from people who said, this is overtly political and you should leave the Supreme Court alone. And what happened to stop the court packing plan was that one of the justices, the next time one of FDR's programs came to the Supreme Court for review, that particular justice, Justice Roberts, changed his vote, and he voted to say that the FDR program was legitimate and justified. And so that ended the court packing process, because now FDR could count on getting his programs approved by the Supreme Court. That change by Justice Roberts is often referred to as the switch in time that saved 9, because if he hadn't switched, there would have been more than 9 justices. So that's probably the most famous effort by a president to try to alter the Supreme Court for clear political gain. Hope that helps, Eric.
That was very helpful. Thank you. And there was a question that refers to the quote-unquote fake courts and trials. And there was a reference to Stalin's fake courts and trials. And the question is, would you classify vice admiralty courts meant to put smuggling cases on trial in the British colonies as quote-unquote fake?
Oh, great question, Victoria. Thank you so much for asking. No, I wouldn't say the vice admiralty courts were fake in the same way that the Stalinist courts of the 1930s were fake trials. The difference was that the venue meant that there was a greater likelihood of conviction, but it wasn't a guarantee. For folks who want to know more about it, I'm going to put a guy's name in the chat. His name's Karl Ubaloda, and Karl Ubaloda wrote a great book about the Vice Admiralty courts of the Revolutionary era, in which he went through the kinds of material that Victoria is really interested in. But basically, those Vice Admiralty courts operated without a jury. But that didn't mean, unlike a common law court where you would typically get a jury for a smuggling case, the Vice Admiralty courts operated without juries and with judges alone. But that didn't mean that you got an automatic conviction. And so I would just say they weren't as clearly a fake kind of trial as the ones during the Stalinist purges of the 1930s.
Okay, I'll bring one more to your attention and then we will move on. This is actually from Ryan. His question is I'd love to hear more about what the options were for the shape, the size, and scope of the Supreme Court. What were some of the founders' strongest competing arguments for the court we have? What were some of the founders' strongest competing arguments for the court we have in terms of shape, size, and scope?
Ryan, that is a complex question, and one that really isn't one I can even give you a partial answer to in, say, 2.5 minutes, but I'll give it the good old college try. Article 3 of the U.S. Constitution does not specify the size of the Supreme Court. There is no language in the U.S. Constitution that specifies how many justices will serve. It doesn't specify, it spells out some of the areas that could be heard as cases by the Supreme Court, but it doesn't list all of them completely. And the actual size and scope of and shape of the Supreme Court was actually pounded out as part of the Judiciary Act created by Congress in 1789. And so that's where actually some people who came in with one set of ideas about the Supreme Court were surprised to discover how broad its jurisdiction was going to be. Just to kind of cut all this short, the Constitutional Convention in 1787 didn't talk very much about the Supreme Court, and part of the reason they didn't was that they spent a lot of time talking about how the president and or members of the legislature were going to play a role in overseeing court decisions and reviewing things that we might term unconstitutional. And it took them a long time, it took them months to get off the subject of and decide to scrap the idea of a council of revision or a council of censors that the president would participate in. And so by the time that they got around to discussing the Supreme Court, they basically said, there shall be one Supreme Court and such inferior courts as Congress shall from time to time deem necessary. And that's it. And so they left it. They basically punted. They kicked the entire mess down the road and said, we're going to let Congress sort it out. And this is also shaped by the fact that they came from different states, and the states had all sorts of different ideas about what the court structures should look like. To use a baseball analogy, since we're on a baseball night and the World Series is getting ready to be played, it's kind of like the old adage about the Boston Red Sox, 25 players, 25 cabs. They came to the Constitutional Convention with experience of their own state constitutions, but every single state constitution was basically different on this point. So there wasn't agreement about what it should do, but there were two large camps, and one thought that the Supreme Court would have a fairly limited jurisdiction and would hear very few cases, and that there would be a minuscule federal judiciary as a whole. And the other side wanted a very strong judicial branch. They wanted a large jurisdiction where the federal courts could hear many cases, And by being vague and ambiguous in the U.S. Constitution, they kick it to Congress to sort out. And what they don't count on is that the very first Congress of 1789 was heavily Federalist, and that Congress decided to go for the big, stronger, centralized national judiciary with a broad jurisdiction. And so there are some people who felt betrayed and unhappy by that decision. So even after it happened, there are folks who think that it shouldn't have. And I hope that provides you with some help, Brian.
All right. Thank you so much. We're going to move on. Again, if there should be any other questions, feel free to drop them in the Q&A chat box. Thank you.
Okay, so now we're going to take a closer look at the world of English and colonial law, or a time that might be otherwise described as when there was no one Supreme Court. There are a lot of things we take for granted about our current legal system, and among those are the idea that there's one and only one legal system in our country. And so some of the material that I covered in the book's first chapter and that you read about in the brief essay on colonial law is about the presence of multiple legal systems in early America. You know from your reading in the overview I gave you about colonial law, and particularly the encyclopedia articles, that there were plural legal systems in existence in early America, and that English common law only came to predominate when English settlers outnumbered those from other countries. And so the book begins this way by showing the reader how in early America, common law existed as one of several competing legal systems from the 1600s into the 1700s. And part of this means that I have to, in a very, very short period of time, unpack the French, Spanish, Native American, English, and other legal systems, and also explain fairly briefly the contemporary political theory behind that. And we need to acknowledge that the people living in that time had choices. They had options for where they and how they would resolve disputes and get justice. Now, somebody from Goebbels' generation would say, hey, why bother? If we end up with good old English common law, why explain all the alternatives? And the answer to that is you're letting the endpoint dictate the course of the story that comes before. Good historians don't do that. We show all the options on the table so that then we can say people in the past had these options available. What might they have chosen? What didn't they choose, and why? But Goebbels was really only interested in talking about English common law, and in his book, you don't get anything about all those other legal systems. So I talk about arbitration that the Quakers used, or church courts like what the Puritans used, and also what constituted a final judgment. Now, we are accustomed to the principle of finality. You take a dispute to the judge, she hears what your facts are, she delivers a ruling, one side wins, one side loses. There may or may not be a chance for another court to hear your dispute again. If it gets heard by a different court, we call that an appeal. Well, a big question in the colonial era was, did you have the right to an appeal? And if so, how did you do it? And who would hear that case? Theoretically, you could appeal a case from the local level to potentially a higher level, but it's not at all clear where that higher level was. Was it the governor, or was it the legislature, or was it a different group of judges, or maybe the governor and his council? And was there even another chance to appeal beyond that, possibly to England? Well, part of what happens is explaining the very concept of an appeal. Appeals are tricky because if a judge has listened to all the evidence and rendered a decision, why should there even be an appeal? Appeals are important to us now because we think of maybe the judge made a mistake or something like that. But when you talk about taking a case from a lower court to a higher court, you're talking about the precursor to judicial review. And of course, judicial review interests people a lot when they're thinking about the Supreme Court. Well, in the English and colonial period, appeals were a very tricky thing. They were not automatic, and it wasn't always clear if you wanted to appeal who you should go talk to. More on this in a moment. Another thing we take for granted is thinking of branches of government as having functional differences. We expect lawmakers to sit in Congress or a state legislature to make laws. We expect the president and his agencies, or a governor and her agencies, to administer the laws. We expect courts to hear disputes, and never the twain shall meet. We expect none of those branches to do the other branch's business. But these kinds of functional differences didn't exist in the early modern period. Political philosophers like John Locke and the Baron de Montesquieu wrote about the nature of government. But men in the early modern period didn't even agree about what the core functions of government were. Today we automatically rattle off, executive, legislative, judicial. Those are the three branches of government. But in that time, a man as learned as John Locke concluded that the three branches, the three key functions of government, were the executive, legislative, and federative. And for those of you who don't know what the federative is, that's another word for diplomacy, a government's foreign policy. Nobody then automatically assumed that the government had the same three functions of government that we now assume that they had. And so that leaves us with a question. Where were the courts? Well, they could be executive, legislative, or even both. Okay, so now we got to go back to English legal history for just a bit. Our early courts evolved out of English practices, but it might surprise you to learn how tangled and convoluted their history of courts actually was. The first lawgiver and judge in English history was the king, but the king's a busy guy, and so he often asked for advice from his closest friends and advisors. And that's where Parliament originated from. Parliament wasn't just any random group of lawmakers. Parliament originated from the king's close advisors. When he said, should I make a law on this? He turns to his advisors. They say, yeah or no. However, those same advisors played multiple roles for the king. They weren't just his parliament. Those same advisors might hear disputes that ordinary English people wanted the king to decide. But, the king's a busy guy. And so he'd ask his close advisors, if he couldn't be present, to resolve the disputes if he couldn't be there. And that's the origins of the royal courts of justice. And last but not least, the king's advisors went on giving him advice about his realm, wherever the king owned land. The group of advisors might hear disputes that came from faraway parts of his kingdom, like the bits of France that England owned for a long time, or Ireland, or later the American colonies. And this group of advisors came to be known as the King's Privy Council. So all three bodies, the Parliament, the Royal Courts of Justice, and the Privy Council, might hear disputes and decide their outcomes. And for a very long time, it was possible to have your lawsuit heard by whichever one you found it easiest to gain access to. So, of course, to gain entry to the Privy Council or to the Parliament, you might have to be extremely wealthy, or maybe even an aristocrat, which is why the majority of suits, but not all of the lawsuits, flowed toward the Royal Courts of Justice. But you could still get a case heard in Parliament or the Privy Council. And the other thing to understand is there is no hierarchy of these three different bodies. That's the reason why all three of these pictures are on the same level. One of them is not higher than the next because the king can participate in all of them, and the king is the source of justice in England. Okay, so back to America. That's the point at which we get to early America. The king delegated his authority via charters to set up courts in North American colonies in the 17th and 18th centuries. And when you looked at the charter language like you did in the reading about the Connecticut Charter, you probably noticed that it was pretty vague about how many courts there might be or what kind of personnel were going to staff them. The vague language in the charters set the stage for many different groups to get into the business of resolving disputes, just like what happened in England with the king, parliament, the courts, and the Privy Council. In the colonies, who could hear disputes? Well, all of the individuals or groups that operate like those in England. So, the governor, sort of like a king, the governor and his council, sort of like the Privy Council, the legislature, sort of like Parliament, and colonial courts, sort of like England's royal courts. The language in the charters had indefinite, ambiguous wording, which allowed colonists to interpret those charters to their own advantage. Now, colonists treated these charters like they were written constitutions that were fixed and laid out their privileges as subjects, not really being aware that whatever the king granted as a charter could be revoked by the king for any or no reason, from failure to colonize to he just felt like taking the charter back. But the early and mid-17th centuries had a lot of silences, and that gave colonizers a lot of room to innovate and do things that were different from England. And this is where we get to governors and their work as governors and councils and their work as judicial bodies. In the colonial era in American history, governors' councils could take on what we think of today as judicial work because nobody at that time thought of what the councils were as exclusively executive bodies, just the same way that nobody thought of the Privy Council back in England as exclusively an executive body. So imprecise charter language opens up a whole realm of possibilities in terms of possible court configurations, and not surprisingly, variations existed from colony to colony. So in New England, courts first developed around towns, whereas in the South, the courts are developed first around counties or parishes. And the charter language was really vague about appeals and lacking clear political direction about who should be dispensing justice. Both the legislatures and the governors fought for legal business. And here's why. Because doing legal business meant payment of fees to the people who heard the disputes. So they got paid more. So in the 1650s, Rhode Island's assembly authorized a traveling general court of trials to hear criminal suits, where the governor would preside as a judge and the other justices would be drawn from members of the legislature. Parties who were disappointed could appeal for a second hearing before the very same group of guys. In Virginia, lawyer and Burgess William Fitzhugh analogized a legal appeal to the House of Burgesses with an appeal made to Parliament. And at these appeals, new evidence and new witnesses could be admitted. There weren't rules that said an appeal was limited to only considering errors that were made at the lower trial. Whether it was argued before a legislature, a governor and council, or a court, if there was a second hearing, typically they reopened the entire case to be reheard. The Massachusetts Superior Court of Judicature, which was the equivalent of their Supreme Court, routinely heard cases twice. So suits that were heard by a governor and council covered a lot of ground. They heard cases that were civil or criminal or based on divorce and remarriage, or they were about maritime matters. And the first recorded suit that we know that happened in South Carolina was in 1671. And the oath that members of the council talked about the need for them to be impartial. Here's the oath of the office of a South Carolina counselor. You shall do equal right to the rich and to the poor, and demean and behave yourself as to equity and justice appertains. So the point here was that they were expected, when they were put into office, to act like justices. Now, all of this looks pretty strange to modern eyes because we think that judges in courts are the ones who dispense justice. But these practices in early America were following the English model. And that's the setting for the Levine case, one of the documents you read for this webinar. And in that document, you read how Connecticut residents tried to stall or delay or even prevent any kind of appeal from reaching England, because the people like the Hallam brothers believed that their case ought to have another appeal before the Privy Council. But let me give you a little bit of insight about the appeals like the Hallams made in the 18th century. You might have been thinking after you finished reading that the Privy Council began to step in and offer all kinds of clear answers to appeals that crossed the Atlantic, right? Wrong. Even after the Privy Council began encouraging appeals to their body, starting in the 1690s and into the 1700s, clear decisions were not always made. When the Privy Council heard a colonial case anytime after the 1690s, they might never make up their minds, which only set the stage for more confusion about whether a judgment was final, whether a final decision had ever been reached. And in fact, the total number of appeals left by the Privy Council without any decision gradually increased through the 18th century. Now, folks who've studied the Privy Council records, the editors of those records, suggest that the administrators became sloppy and lazy. That's their words. Slovenly and dilatory are exactly what they said. By the early 18th century, which might account for how many appeals that went to the Privy Council never got an answer, never got a resolution. We find it hard to believe that a court might hear an appeal and then never issue a decision. But this was pretty common for overseas appeals like the Hallamses after 1700. One possibility is they just got overwhelmed with work. But if that's the case, it's kind of hard to understand why they were willing to hear cases a second time. The only answer that seems to make sense is they wanted the fees. They wanted the money to hear the case on a second occasion. But by the early 18th century, appeals to the Privy Council dragged on interminably and frequently showed no sign of actual resolution. So I think people are pretty surprised by the degree that there were such muddled processes for appeals in most colonies and cases like the Levine and other. They might be surprised to learn that when an appeal happened, frequently what mattered most was that the case actually qualified based on monetary value. It had to meet a minimum value to be heard. In terms of what governors and councils are doing, excuse me. Just take a drink of water there. In terms of what governors and council members were doing, when they heard appeals, typically by the middle of the 18th century, they had set a minimum dollar value or minimum British pound value for how much the case had to be worth, for it to be worth it to them to hear it. Typically, it would be a suit worth £100 and later 300 pounds. Now, if you're wondering how much that is, you can build a 2-story house and completely furnish it in the late 18th century for 250 pounds. There was the real possibility that you might decide to appeal your case to the governor and council. You might not like what they did, and so you might, like the Hallams, decide to appeal your case to the Privy Council. But the Privy Council had even a higher minimum to hear your case. The Privy Council wouldn't get involved unless the suit's minimum value was 300 pounds and later 500 pounds. Colonies did whatever they could, like Connecticut, to stop the Privy Council from hearing appeals. But in fact, the biggest roadblock was probably the case value, the idea that if the value wasn't high enough, then the case appeal might be denied. It was the high cost of appeals, the remoteness of England, the difficulty of transatlantic traffic, rather than any kind of procedural barriers, that probably kept the majority of appeals within the colonies in the 17th and 18th centuries. That's probably why most suits stop with the governor and council or the legislature. So that meant appeals out of the colony were typically only open to colonists who had a particular level of wealth. So the governor and council might be the last stage of appeal that most colonists would ever know. So what the governor and council are doing, their role as a court of appeal and a final court of appeal, really isn't terribly well understood. That's part of what I'm trying to change here. So in any case, all of this is really sort of confusing. And, we assume if a court hears a case, then there ought to be an answer. And it's very strange sometimes to hear that a case might be reheard and then reheard again. But remember the Hallams, of course, the Hallams who asked for multiple rounds of appeals. And of course, there were multiple avenues for dispute resolution in early America. You could go to arbitration. You could go to the local church court. You might go to your legislature. You might go to the governor with or without his counsel. All of this means that this is a kind of a complicated picture, even after we get into the middle of the 18th century. Imprecise words in charters, combined with a lack of any kind of coordinated central authority by the English crown, meant that there was a wide variety of courts, many legal procedures, a lot of different appeal processes available. Those charters basically are just kind of like a starting point. And the colonists ultimately are going to have to develop a new system, a new set of systems that will be like the English models and yet unlike them in a number of ways. A South Carolinian wrote in 1730 that there are not two colonies where the courts of justice or the methods of proceeding are alike. Okay, so I'll give you an extreme example now. To take an extreme example, in Georgia, there was no single state Supreme Court until 1846. You heard me right, 1846. So part of the reluctance to have an appeals process that involves sending a case away to a distant group of people to be resolved, part of people's reluctance to do that is because they don't trust people who are not members of their local community. And whether or not they were sending the case to be heard by people in Milledgeville, Georgia, or London, England, those places are often so far away from where the dispute happened that there's something of a distrust built into the process of appeals. It's not just guys in Georgia who are very uneasy about appeals at all. And so by the time you get to the American Revolution, there's no one single way no one single process of court structures, court processes, or even how an appeal would be handled to a final conclusion. The notion of one Supreme Court that's the final arbiter was really still in development. And so that brings us to the final question, the one that I'm sure some of you are wondering. Where do we get our idea of a Supreme Court from? The Revolutionary era state constitutions are really where part of the answer becomes more apparent. Starting in 1776, the states began to write their constitutions, and it's in those state constitutions that we begin to hear about a functional separation of powers. So let's look at the Virginia State Constitution of 1776. The language there says, the legislative and executive powers of the state should be separate and distinct from the judiciary. It's one of the very first statements that separates those three branches or sets of powers from each other. And in the Virginia Constitution, they develop a multi-tiered judiciary that has a court of admiralty, a court of chancery, but it also has something called a Supreme Court of Appeals. And in the same vein, we can look at the Delaware Constitution from 1776. The Constitution there established a final court of appeals. But in Delaware's case, we still can see some of the confusion that's going on, because the Delaware Supreme Court of Appeals was designed to hear cases being appealed from its Supreme Court. That is to say, it's got a court of appeals, a final court of appeals, to hear appeals from its Supreme Court. So Delaware is a funky example of when is Supreme not really Supreme. New Jersey, Pennsylvania, several other states follow along to create Supreme Courts, but not all of them did. See New Hampshire. The first state constitution of New Hampshire has no Supreme Court. Just because they set up Supreme Courts doesn't mean they've got all of the problems worked out. But I do want to bring this to a conclusion and say that even if there wasn't one Supreme Court in England or early America, it's in the revolutionary generation that we begin to see the start of something that we might think of as supreme, something that is final, and someplace that might be, except in Delaware, the final round of the final place where there are appeals to be heard and resolved. So let me stop there, and let's see if we've got some more questions or things that have come in that I can help with.
All right. Yes, we are getting to the end of our time, and there was one question from earlier, and you touched on this some, but I'll go ahead and present it. It's from Andrew. Andrew put this in the Q&A chat pretty early on, but he said, if you could identify the biggest difference between the early Supreme Court and the court of the latter half of the 20th century, Andrew also includes in the present court, what would it be? And that's a very broad question. But I wanted to see if you could maybe
I'll
give
take
him
a swing
a
at it.
response. Good deal.
I'll take a swing at it, Andrew. The biggest difference that is between the early court and the court, say, of the latter 20th or early 21st centuries is that we don't make Supreme Court justices ride on circuit anymore. The justices who served on the early Supreme Court were supposed to pull double duty. That is to say, they were supposed to hear cases that came to them as Supreme Court justices, but they were also expected to ride on circuit and sit in local trials that were held at the circuit court level. And so you're saying, well, wait a minute, if they hear it first at the circuit court level, then what happens when the case gets appealed to the Supreme Court? And you would be exactly right to wonder that. But this goes back to that whole question of what is final and what is an appeal. The text of the Judiciary Act of 1789 spelled out how the justices were expected to go out and ride on circuit. And people like Justice Iredell of North Carolina rode 1,000 miles on horseback to cover one Southern Circuit Court of Appeals for a single year, or so he claimed. The justices today not only don't have to ride circuit, they have a lot more control over the cases that they choose to hear and not hear. They have complete control over their docket in a way that the early justices did not. So that's the biggest difference between then and now.
Perfect. Thank you so much. Everyone, thank you for your attention. Thank you for your questions. Thank you for your engagement tonight. We're going to go ahead and close out now. Sally, I cannot say enough. We began this conversation in the spring when you were here, when I spoke with you about being a part of the series. And again, I can't thank you enough for just spending your time and leading us and guiding us and examining the creation of the first United States Supreme Court and just really exploring court structures throughout the colonial ages and revolutionary America. So we appreciate you more than you know. And I look forward to continued conversations as you complete this project. So for everyone who joined us tonight, we, again, I'm always overwhelmed at the numbers that we have. Those of you who are taking your time to join us and be here, because we recognize that you have busy personal, professional, and social lives. And so, but you're here tonight. For all this happening at the National Humanities Center, I encourage you to follow us at nationalhumanitiescenter.org and also on our social media channels as well, National Humanities and NHC Education. Also, if you are so inclined, support the humanities education programs. The NHC education programs provide a bridge between the academic and the working classroom. Your gift, no matter how modest, can open up a world of ideas for teachers and rekindle their enthusiasm for the subjects they teach by providing the knowledge and the tools that they and their students need to make a difference. So, we're going to have a little bit of a break. We have a busy time coming up preparing for next summer's institutes, and we will devote a considerable amount of our energy and efforts to getting our registration forms together and our pages, as well as some other obligations that we have. So the next time that we will reconvene with you will actually be after the Thanksgiving holiday with Poems and Other Word Machines, December the 3rd, with Seth Perlow. Again, that's December 3rd, and we're looking forward to having Seth with us. If I can assist with anything, please do not hesitate to reach out. As you all very well know, we appreciate you. And again, Sally, thank you for joining us this evening. You're the best. And we will be in touch, my friends. Take care and be well.